Welcome to the midweek edition of Legal AF. Your two co-anchors, Michael Popok, Karen Friedman Agnifilo. Here's the stories we just have to talk about this midweek. The Supreme Court, in the Anderson decision, by, well, let's call it a 9-0 vote with an asterisk, decided that Congress has to create a new set of laws and procedures, maybe a tribunal, in order to figure out who's an insurrectionist or not, and to whether they can be on the ballot. And states can't do that. Were they right, or were they sticking their big fat thumbs on the scale of justice in favor of Donald Trump? Did Amy Coney Barrett, in her 2-paragraph concurrence, say the quiet part out loud that they were meddling in political affairs, exactly what they claim Democratic judges do and activist judges do? Were they activist judges in favor of Donald Trump? We'll break it all down. Then we got to go. My co-anchor, Karen Friedman Agnifilo, former number 2 at the Manhattan DA's office. We got to talk about the Manhattan District Attorney's office getting ready, gearing up for a March 25th trial. There's one person on this network, and she's my co-anchor, who told you that the only trial that was likely to happen before Election Day is likely this one. Not the trial you may have wanted, the trial you're going to get against Donald Trump for business record fraud related to the Stormy Daniels hush money affair. Will Michael Cohen, also a member of the Midas Touch Network, will he take the stand in favor of the Manhattan District Attorney and against his old nemesis, Donald Trump? What about Allen Weisselberg, just pleading guilty to 2 felony counts of perjury? He's a key witness. What happens to him? I want to hear it from Karen, our favorite former prosecutor, about how this battle of Cohen versus Weisselberg, how a prosecutor uses the fact that one of their lead witnesses is staring down the barrel of being sentenced for another, 6 or 8 months in jail on key issues. We'll break it all down with the Manhattan DA. Then, Judgment Day. Donald Trump got to dig deep into his pockets or those of his contributors to come up with $83.5 million running with interest to pay off E. Jean Carroll's judgment, post a bond, get a stay of the enforcement of that judgment, and the $460 million plus, running with interest, $464,940,000 running in favor of the people of the state of New York through the New York Attorney General civil fraud case. Why is this Judgment Day? Because on Thursday, tomorrow, he's got to come up with the bond or the cash for E. Jean Carroll, or she's going to start executing on her judgment. He can take the appeal, but he can't get the stay of the enforcement of the judgment and the clawing back of his assets without posting the bond. We know he's got $100 million because he just told the New York Attorney General emergency appellate judge that he wants to post $100 million over there. Well, he better post the $100 million, because that's about what it's going to be, through a bonding company over here with E. Jean Carroll, or she's going to own his penthouse, or, Mar-a-Lago, or something that gets her $83.5 million. We'll break down what it means. Why is it taking Donald Trump so long? What is he waiting for? Can he even get a bond? And if he doesn't get the bond, where is he going to scrape up the $600 million or more that he needs to stop the enforcement of these judgments? And then we'll talk about Chesebro. A civil lawsuit has revealed 1,400 text messages and emails between him and a guy named Jim Trupis, a Wisconsin lawyer who worked with Chesebro on the fake elector scheme at the behest of Donald Trump. You may remember Ken Chesebro is a convicted felon, having already pled guilty in Georgia to election interference, and then was given permission by Judge McAfee in Georgia to go on the road and cooperate with the attorney generals of Michigan, Arizona, and Nevada. But now it looks like he lied and may have committed perjury in the information he gave them. Yes, he did it under a proffer agreement and an immunity agreement, but if you lie, the immunity deal is off. We'll talk to our former federal prosecutor about that. What am I talking about? He told the prosecutors and the attorney generals that his recommendation and advice as a lawyer was the only way you could use the fake electors, the only way you should use them and those certificates, those alternate slate of electors, is if there's success in the lawsuits filed by Donald Trump in the 60 or so cases that were filed, and only if a judge in the battleground states overturned the election results, then you use the alternate slate of electors with Mike Pence. That's a lie. How do I know it's a lie? Because in his own emails between him and Jim Trupis at or about the same time, and in social media posts that he made using a burner account labeled it'll come to me, don't worry, Badger Pundit. There it is, Badger Pundit. His burner account. He posted his true feelings, which were, you don't need the lawsuits, just use these fake electors, throw them in, throw a monkey wrench into the process, and maybe it'll get turned over to the House of Representatives to pick Donald Trump as president. You can't talk out of both sides of your mouth, the prosecutors. There's a word for that. It's called lying under oath and perjury, and you can go to jail for it. We'll break it all down. Where else? At that podcast, hopefully you've come to love, called Legal AF. Only on the Midas Touch Network. There she is. Karen, first, are you feeling better? Because last week you were under the weather.
Last week I was under the weather. I spent the whole week being very under the weather, and I'm starting to come out the other end of it. So yeah, right. I feel much better. So even if I sound not 100%. Hey Popok, do you have a burner social media account? Like, it's so funny because so many people.
On me.
No, but I just, it's funny. My kids always had a Finsta, like a fake Instagram. They'd called it a Finsta. It's like whatever, but it's just interesting. It's amazing to see a Harvard educated lawyer who is advising the former president of the United States that he too has his Finsta or whatever it is, where his true feelings come out. It's just sometimes when we talk about these things, it's just shocking to me.
Well, wait till we put up in our production here the picture of, just to remind everybody, Ken Chesebro, who's a self-proclaimed election law expert, half-baked constitutional scholar, walking around during the insurrection of Jan 6 wearing his MAGA hat as a guest of Alex Jones. You can't make this stuff up.
You really can't.
If you made it up, nobody would make this movie or watch it. So let's dive into our first story today, which is people know what happened, but we like to talk about what happens next and follow these events on Legal AF at that intersection of law, politics, and justice that we like to talk about. So we got a Supreme Court decision. We thought it was 9-0, but now, having seen the metadata, which I'll let Karen talk about, I'm not so sure. But in any event, at least 9 justices thought that that a state cannot ban a federal officer or federal candidate from the ballot in their state under their interpretation of Section 5 of the 14th Amendment, which has always been interpreted as an enabling statute, which allows Congress to pass laws to effectuate the intent of a constitutional amendment or a piece of legislation. For instance, I get that the 14th Amendment, in attempting to protect the newly installed rights of newly freed slaves, now Black Americans, to give them back the civil rights that, of course, they lacked, give them back and give them voting rights that they lacked, to give them equal justice and equal process under the law and due process under the law, passed a series of actual laws that ended up on the code books. I get that, but that's not what Section 3 of the 14th Amendment says. So the Supreme Court started off on the wrong foot on purpose because they wanted to put their big fat noses into politics, as Amy Coney Barrett, and I'll do it after you're done with your analysis, Amy Coney Barrett said in her concurrence, which is exactly what they were doing. And they said, oh, well, it's right there the whole time. Section 5. Everything goes through Section 5 in the 14th Amendment, even Section 3. No, it doesn't. It couldn't possibly. So their ruling is that Congress, only Congress, can set up a procedure, a new set of laws in the Code of Federal Regulation to remove a federal candidate who's an insurrectionist and engaged in insurrection against the Constitution, even though it doesn't say that at all. And Section 3, by its very terms, does not require any enabling laws to go along with it. It stands alone the way that it is written. And to undermine their own analysis, talk about internal inconsistencies, they say in this exact same paragraph and in this exact same breath of their analysis, in the Anderson case, they say, we're okay with the states under the 14th Amendment, Section 3, taking state candidates who are insurrectionists off the ballot, but not federal. Huh? So what happened to Section 5? I thought Section 5, Congress has to pass enabling laws, but they don't if it's a state, even though it doesn't say that. I mean, this was so upside down, reverse engineered to land right where the MAGA majority wanted it to land, which is that there's got to be one more step and we will kick the can down the road and see what happens until after the election and who actually controls Congress to pass any of those laws, because we know what happens if the Republicans get the House. We'll never see these laws ever passed ever again, and God help us for the next Jan 6th. So I want to talk through with you your takeaway from the Anderson decision. What do you think the next steps are? And what did you make of Amy Coney Barrett's commercial interruption for the United States Supreme Court? This is brought to you by the Supreme Court. We lower the temperature in America. We don't raise it. Really?
Yeah. Tell that to the Dobbs majority.
Exactly. Where was she on Dobbs when she said the purpose of the Supreme Court in this trying times is to turn down the heat and turn down the rhetoric? Well, where were you when a woman's right to choose was being ripped away?
Yeah, exactly. It's crazy. I mean, look, this decision was, I definitely was in the minority of the Midas touch people, because I said there's no way that decision's going to stand, and this will 100% be overturned, the Colorado decision. And look, Judge Luttig, who's one of the smartest people, one of the smartest lawyers, is certainly much smarter than I am on these issues and much more of a legal scholar. I never pretended to say, oh no, my analysis is better than his or the other extremely brilliant lawyers who opined on this issue. But from a just practical standpoint, there's no way the Supreme Court could let that stand. And so it never surprised me that this would be the case, because it can't be the case. You can't, otherwise you have to, there'd be chaos in the country. You have to have some uniform standards. And the thing is, unlike age, or you can't serve more than 2 terms, whether or not you engaged in an insurrection is a little murkier. It's not black and white, like whether or not you're 35 years old or whether or not you were born in this country and as a natural born citizen, et cetera. And so as a result, and language in the Constitution that exists only in this area, but not in other areas, like the things like age, qualifications, et cetera, that is self-executing. There is murky, ambiguous language in the Constitution. It just doesn't surprise me that they all, not just the MAGA ones, but 9-0, they all decided that this has to be legislated by Congress. So I do think sometimes the court has to be the grown-up in the room and bring calm into the United States. They didn't do it for Dobbs, for sure, but here they did. And although we don't like the answer or like the results, sometimes I think it is good to have a body that just tries to bring peace to the country and certainty. And this, in some ways, brings certainty, at least with respect to this one particular issue. However, there were lots of things that they went too far. They could have just narrowly voted on this one issue, but of course they went too far, in my opinion. And that's where Amy Coney Barrett came in and said, look, why do you have to go so far? Let's just decide this one question. There's no reason necessarily to go so far. And that's the same thing that the concurrences, the 3 liberal justices also said. It was interesting. It was sort of girls versus boys. You know, the 3 women all carved out and went off to the side. Even Amy Coney Barrett with the 3 typically or traditionally liberal justices. And they all did this concurring opinion. But what I thought was so interesting was that the Supreme Court did a little bit of a rookie move. They didn't, it's the difference between when you send something to someone, you have to PDF it, right? When you email it, because if you don't PDF it and you just send it as a document, the people on the other end could sort of do the reveal codes, and they can tell where were the edits, where were the changes, because it's called metadata in a document, right? And you have to be careful with that, especially as a lawyer. And every one of us has gotten burned by it. I don't know about you, Popok, but I've gotten burned by the metadata thing before when I was at the DA's office in the beginning, when these things, I don't want to say when computers were new, but when this sort of thing was new, we all know now, but years ago, we didn't necessarily know about metadata. And of course, prior drafts of a speech that Cy Vance was going to give might have come out, or prior versions of a press release, or prior versions of things that you don't necessarily want out there, right? But here we are in 2024, and this is the Supreme Court of the United States. I was a little surprised that this could still happen, and they forgot to PDF the concurrence. And what it showed was that the three liberal justices, when they looked at the metadata, when they did the reveal codes, it was originally fashioned as a dissent. It was not a concurrence. And so apparently that's probably what took the Chief Justice so long to come up to this decision, was negotiating that this would be a concurrence. Keep the language the same, keep your issues the same. But let's change it to a concurrence. Yeah, there it is right there. It's a dissent. Make it a concurrence so that they could say it's a 9-0. It's a 9-0 decision with a concurrence. Because if it would have been a dissent, the three people, it would have been 6-3. And then it would have looked political, because it would be the conservatives, the liberals. This way, because if you say it's 9-0, it takes it out of the realm of politics and makes it much more legal. And so that was important, I think, for the Chief Justice to bring legitimacy back to the court. They've lost a lot of legitimacy, especially with the Dobbs decision and other decisions like it. And I also think they know they are about to rule, in April, oral arguments will happen on the presidential immunity case, right? And the January 6th federal case in presidential immunity. They have that, and they have a few other cases that I think are also ones that they're going to want it to look legal, not political, right? There's also a case, I think it's Fisher. There's a Fisher versus the United States, which was Joseph Fisher is one of the participants of the violence in the January 6th case. He was charged with corruptly obstructing an official proceeding in violation of Section 1512C2. Why am I bringing that case up? Because 2 of the 4 charges against Donald Trump are that same obstruction of an official proceeding statute. And they're going to have to decide whether that statute was properly applied to January 6th. Now, obviously, not the whole world isn't really focusing on Mr. Fisher, but they're focusing on whether that will stand in the Washington, D.C. case. Will it apply? Will those charges stick if it does go to trial before the election? And so they have a lot more cases to decide. And I think it was important, because whatever they do, they're going to want it to be legitimate. And it's fairly clear that if they follow the law, that they will find that Donald Trump is not immune. And so therefore, because the law, if you read the law, is not that, right? We saw the DC Circuit oral arguments when the SEAL Team 6, the infamous or famous SEAL Team 6 hypothetical that Judge Pan gave, that shows the absurdity of giving full immunity, even for things that are within the outside perimeter or the job description of the president. He can't have full immunity from criminal prosecution. So there are several decisions that the Supreme Court will be coming up with soon, I think, that show why they have to instill legitimacy in these decisions.
Yeah, I'm not as optimistic as you are. I don't think this was an attempt to stay and not play politics. I think it was actually the opposite. I want to see how Amy Coney Barrett and the rest apply this new principle, apparently, the new principle is the court in certain circumstances should turn the national temperature down, not up. I want to see how they apply that. I would think that the immunity decision would be an easy one for them to make, to uphold the District Court of Appeals decision that there is no absolute immunity for criminal conduct that's done by a president outside his official duties or others. And I am heartened by the narrow grounds that the appeal is going to rise and fall on, because they did reject almost all of Donald Trump's grounds to overturn the DC Court of Appeals decision that he didn't have immunity. They've completely overturned and they've rejected the argument of due process and First Amendment, and you've got to be impeached and convicted for all that's gone. In fact, the only narrow issue is the one that they framed. Can a former president of the United States use immunity against official acts? And I think that's very telling. I did a hot take on it. I think that's not a life preserver for Donald Trump. That's an anvil that's being thrown his way, because all they have to do is rule that either, I think they liked and found pretty much airtight the analysis by the District Court of Appeal. However, they don't want to keep touching the third rail of presidential immunity decisions, and they only want to do it once. So if they're only going to do it once, then they want to just get a couple of other things right that weren't exactly addressed in that 60 or 70 page order. And I think the two loose ends that they want to tie up is whether it matters whether the person's a former president or not when he attempts to apply the immunity. They want to get that settled once and for all, and because they want to make this like one fell swoop of a decision, and they want to settle the issue of official conduct versus things that are outside the outer boundaries of official conduct, which is something we constantly talk about on the civil side, about what is inside and outside the outer boundaries of the official duties of the president. I think that's what they're going to try to do. And if that is all they're doing, and that's all they say they want briefing on, then that does not bode well for Donald Trump in that decision. We'll know more on April 25, because we just got it set today. The oral argument is going to be, we thought it was going to be on the 22nd. It's going to be on the 25th, the last oral argument that they're going to hear. I don't know, not for the term, but for that session is going to be that one. And we'll see what lawyers stand up to the plate. Is it going to be the same lawyer, John Sauer, and John Lauro, or is they're going to bring in a new team because that team didn't do great in front of the DC Court of Appeals? I think they're going to sort of they're going to ride the horse. They're going to ride the horse they brought to the race, and they're going to use Sauer again. On the metadata, it was not exactly. Sotomayor's originally was going to be a dissent in part and a concurrence in part, and Roberts obviously was able to work it and make it be a concurrence in the judgment, so that they could make the announcement of 9-0 and let Amy Coney Barrett do her proclaiming. Yeah, you see it there. Her proclaiming that we're just doing what's right for the country. We're not playing politics. They're supposed to stay out of political questions. They're not supposed to actually say out loud that they're going to settle a politically charged issue. I almost had to rub my eyes when I read that. The United States Supreme Court and the conservatives on the court constantly using the political question doctrine to not make decisions and not stick their face and their nose and their thumbs onto the scale of justice. Now they're saying we got to do exactly that. We got to solve a politically charged issue because there's the presidential elections coming up. Really? So And as to the minority majority on the, I'd be remiss if I didn't remind us that Ben Maisala said 9-0, and he was right. I said 7-2. I was more hopeful until the oral argument. Once the oral argument happened, despite my interviewing, speaking of Judge Ludig, I'm doing a follow-up interview with Judge Ludig for Legal AF this week. And we're going to talk about what happened, what backfired with the analysis on the Anderson case, and what he expects to happen with the immunity decision. And then we can talk. I'm going to try to bring him into what's going on and have him comment on Judge Cannon and what she's doing down at Mar-a-Lago, with some new reporting today. We won't do it as a segment, but some new reporting today that she thinks it'll be very helpful to read some briefs by Stephen Miller, who used to work for the president and has some phony law society thing that he set up. And she thinks it's very interesting to find out if Jack Smith was actually properly appointed and his budget was properly approved or not, and thinks it's very interesting to find out from these right-wing MAGA briefs whether the National Archive, and the role and whether they've overstepped. I mean, it's just fascinating to watch somebody that is, I used to just say, she's inexperienced, and I can't say that anymore. What is going on with Cannon? Let her make her decision, and let the 11th Circuit, who is, I'm sure, chomping at the bit to rule here against her. Jack's got to find the moment. I'm surprised it hasn't happened. He's just waiting, I'm sure, for the decision on the witnesses and her order on the motion to reconsider. And I think we're going to see lickety split an appeal to the 11th Circuit and a request to have her removed. He's waiting for the order to come out. And the order hasn't yet come out, at the hearing having been last Friday on that.
From what you're saying right now, this issue about Judge Cannon and hearing these amicus briefs that are just kind of outrageous, right? Saying this is going to be helpful, these right-wing amicus briefs. Lisa Rubin, who is just really somebody to follow on Twitter. It's Law of Ruby. She's super smart. She just tweeted out today that in the Mar-a-Lago records case, 2 lawyers from the special counsel's team just entered notices of appearance. One argued the gag order at the DC Circuit. The other argued the immunity appeal at that court. To folks watching for when and if the special counsel's office will appeal a Cannon order, this could be a sign that they're gearing up for one. So I just thought that was interesting that today, that's given this, what you just talked about, that's triggered this.
Yeah, I agree with you. He's got as you've noted in the past with the Manhattan DA's office, where we're going to go next, in a moment, we can read a lot into how the prosecutors strengthen their bench and the talent that they assign at any given moment and what it means for the future. We're going to break it all down. We're going to talk about the Manhattan DA's office and its March 25th trial and the motions that have been filed against Michael Cohen, taking the stand by Donald Trump's side. What does it mean that Allen Weisselberg, the chief financial officer, the money man, through which all of the decisions about money and business records for Donald Trump flowed, has now admitted to perjury and is now a convicted felon again, and is looking at another 6 months or more in jail? And then we're going to talk about Judgment Day. What's Donald Trump going to do? Is he going to come up with the money? He's got to come up with $100 million by tomorrow. Where is he going to get it from? How is he going to post? If he posts that, where is he going to get the money for the other judgment that's 20 days later for the New York Attorney General? And then we're going to talk about how big of a mess Ken Chesebro has made by getting permission to go on a whistle-stop tour of attorney generals and then apparently lying to them about the fake elector scheme. And what does it mean ultimately for Donald Trump? We'll do all of that. But first, a word from our sponsors. Taking care of your health isn't always easy, but it should at least be simple. That's why for the last 3 years, I've been drinking AG1 every day, no exceptions. This routine has taken the place of my old routine: OJ, a swig of coffee, and whatever gummy vitamins were on sale. And I wonder why this didn't really work. But with AG1, it's just one scoop, mixed in water once a day, every day. Instead of sluggish and run down, it makes me feel energized, focused, and ready to take on the day. That's because each serving of AG1 delivers my daily dose of vitamins, minerals, pre- and probiotics, and more. It's a powerful, healthy habit that's also powerfully simple. With AG1, without even thinking about it, I know I'm automatically getting essential brain, gut, and immune health support with vitamins, probiotics, and nutrients from Whole Foods. I like to think of it as a nutritional insurance, which with my growing family, I need. I know I'm covering my nutritional bases right from the start of the day. If there's one product I had to recommend to elevate your health, it's AG1. And that's why I've partnered with them for so long, a product that I've been using and endorsing since I co-founded Legal AF more than 3 years ago. So if you want to take ownership of your health, start with AG1. Try AG1 and get a free 1-year supply of vitamin D3 plus K2 and 5 free AG1 travel packs with your first purchase, exclusively at drinkag1.com/legalaf. That's drinkag1.com/legalaf. Check it out. Your dog, like my Lily, is a member of the family, so serve them the top quality food they deserve. Serve them Nom Nom. All dogs are individuals and they deserve to be served like it. Nom Nom delivers freshly made dog food personalized to your dog's preferences and unique caloric needs. Nom Nom is made with 100% premium ingredients. That means 0% freaky fillers or funky stuff. Dogs love great tasting meals just like us, yet their nutritional needs are different than ours. That's why Nom Nom's nutrient-packed recipes are developed by board-certified veterinary nutritionists, freshly made and shipped free to your door. Nom Nom has already delivered over 40 million meals. That's because the best dogs, yours, deserve the best food, theirs. As listeners know, my dog Lily is truly part of our family, and I don't know what I'd do without her. That's why I'm committed to only giving her the best. Board-certified vet nutritionists develop each of Nom Nom's recipes to provide dogs with the proper balance of vital nutrients required to thrive. Oh yeah, and they're floor-licking delicious too. Nom Face Assured, or your money back guaranteed, meaning if your dog isn't deliriously excited about dinner, then it's a money back guarantee. Say bye to your boring dog food. Your dog deserves a reason to run to their bowl for every single meal, every single day. Go right now for 50% off your no-risk 2-week trial at trynom.com/legalaf, spelled trynom.com/legalaf for 50% off. trynom.com/legalaf. Okay. I love our sponsors. And just a shout out to Jordy Mysalis, who's one of the people that curates for us and for the Midas Touch Network, our sponsors. And we appreciate them. Support the sponsors. It's not just an ad to go, yes, you can take a bathroom break, but the sponsors are very important. First of all, they support our network, pro-democracy, and all of the content, and especially when they choose, because they choose, we choose them, but it works both ways. They choose to be on our show because of the quality of our audience and the content that we provide. And the way we can repay them, so to speak, is to support them. And we like the products, we use the products, and that's why we do the ads for the products. So let's after that commercial break, let's return to the world of law, politics, and justice at the Manhattan DA's office. Why don't you pick it up, Karen, since it's your stomping grounds, and talk about the Allen Weisselberg perjury, what it means for the case, how you would play your hand of having him now testify in front of the jury. What do? Do you tell the jury up front about the fact that he already perjured himself? How do you make sure he plays nicely in the sandbox, having now been prosecuted and convicted by the same office? And then what to do about Michael Cohen, and how does this impact, do you think, the Michael Cohen credibility issue because of his prior perjury and criminal convictions as the Manhattan DA's office, your old office, gets ready to put on the trial of the century against the former president?
So I want to start with a question for you, Popok.
Okay.
Do you think the Manhattan DA's office needs Allen Weisselberg for this trial? And do you think they need to call him?
Okay, so I'll do it this way. This case has very few moving parts. About business record fraud after Michael Cohen, on behalf of Donald Trump, made a series of payments to Stormy Daniels in order for her to, as hush money, to cover up a sex act that she and Donald Trump had together while he was running for office against Hillary Clinton, so that this wouldn't come to light while he was running, just like his Access Hollywood tape about bragging about sexually assaulting women wouldn't come to light. Same thing. And then the payment gets made through Allen Weisselberg, but Michael Cohen could testify to that. The business records get altered, meaning this is the fraud. The fraud is, instead of writing down payoff to Stormy Daniels for her to keep her quiet, which would have been accurate, it said instead payment for legal services to Michael Cohen and a bonus to Michael Cohen. That was the lie. That's the business record fraud combined with the election interference crime that bootstraps it up to a felony in New York. So Michael could certainly, although Michael has his own baggage, Michael could testify about all of the things that I just said, but doesn't have, and there's other people you and I haven't even talked about yet, which are those lower level vice presidents that Donald Trump can't remember the name of, that work in his organization, that were his undoing in the New York Attorney General case, who came in and said, yeah, I worked with Allen Weisselberg and we changed the books at Donald Trump's direction. That guy. And there's like 3 of them. They could all come in and replace Jeff McConney, he's still probably around, and Allen Weisselberg. He could. And if you never mention, although Allen Weisselberg's name gets mentioned a lot, all right, so I guess I'm coming around to it. If you could get an Allen Weisselberg who's going to tell the truth under penalty that he's already going away to jail, and the jury finds out about that, I think it could be compelling. I think it makes a stronger case. That's what I think. But could you, to answer your question, could you do it without him? Like, he disappeared tomorrow, he stepped off a curb and a bus hit him? Sure, you could still try the case and win, I think, for the Manhattan DA's office. So what do you think?
So I think the conversations, with all complete candor, I have no inside information, even though I obviously have friends who work at the Manhattan DA's office still. I have zero inside information. So just as an outsider looking in, if I were the prosecutor on this case, knowing what I know about the office and et cetera, I would be having a conversation among my team about whether or not we need Allen Weisselberg. And the reason is as follows. So Allen Weisselberg this week was charged with 5 counts of perjury, felony perjury, for lies that he made under oath. And that's a very important distinction. He made lies under oath about material facts, whether it's was during deposition or at trial in the New York Attorney General's civil fraud trial that just recently happened in front of Judge Engoron. And the reason I would be asking myself, do I need him as a witness, is because Allen Weisselberg is currently in the posture, and has been for quite some time, as a cooperator for the Manhattan DA's office, right? He was originally charged with a 17-count indictment of tax fraud, along with the Trump Organization back in November of 2022, I believe. And there was and at the last minute, he pled guilty and became a cooperator and agreed to testify. Now, he never threw Donald Trump under the bus, but he did testify to certain facts. So that makes him of limited value, by the way, because he's telling the truth about some things, but not about everything. So if he were telling the truth about everything, then he would also give up Donald Trump. Why do we know that that's the truth? Because if it wasn't the truth, there wouldn't be any charges being brought against Donald Trump. So if his facts, he has 2 choices. He either has to completely tell the truth about Donald Trump, which would mean giving up Donald Trump, right? And testifying against his former boss and whatever else he is to him. They're clearly very close. Or he's going to lie. And because if he says anything different other than what the facts are alleged in this, that has to be a lie, because that's at least a lie, because it goes against the theory of the Manhattan DA's office case. So I don't think they would put him on. They're definitely not going to put him on if he's going to lie. This is a case against Donald Trump. So either he's going to testify against Donald Trump, or they're not going to put him on their direct case. The fact that he has a perjury conviction. Now, how does that, one might say, well, how's that any different than Michael Cohen? Don't forget, Michael Cohen is testifying, and he too has a conviction for lying to Congress. I don't think it was actually perjury per se. That's just a particular charge, but I do think he's been found guilty of lying to Congress. So the question is, why is that any different, right? Why isn't he just the same as Michael Cohen? And I think it's different for a few reasons. Number one, Michael Cohen, when he lied, he was still under the spell of Donald Trump, right? He was still very much one of Donald Trump's henchmen. And that was part of the crime he was committing on his behalf. He has since completely renounced that and has spent the last portion of his life trying to make amends for that. And he has totally been consistent for the last, 6 years, 7 years, that he has been trying to redeem himself and make up for the harm he caused for the crimes that he committed on Donald Trump's behalf. He paid his dues, he pled guilty, he went to prison, and he's been trying to make amends. And by testifying, he will continue that. And his statements will have been consistent all of this time. On contrary, or I should say, contrast that to Allen Weisselberg, who has never come clean, right? He came clean a little bit and testified against the Trump organization, never against Trump. And as recently as a month ago or 2 months ago, whenever it was that he testified in the New York Attorney General civil fraud trial, he was under oath, right? He swore to tell the truth and raised his right hand in court. And when push came to shove about giving up Donald Trump once again, what did he do? He lied. He lied under oath. And he lied recently, and he's still lying. And the timing of that is important because he lied after he was a cooperator with the Manhattan DA's office, right? He lied while under a cooperation agreement. He lied knowing what the consequences would be. So the fact that the Manhattan DA's office this week took a plea to perjury tells me they want to keep their options open. And they want to keep their options open to be able to call him, which is why they made sure to do it before trial. They also allowed him to plead to 2, not all 5, which the significance of that is going to have to do with, I'm sure, how his potential testimony at this trial will play out. There's a reason why they made him plead to certain ones and not. At a minimum, what they did, though, was they neutralized him. So by making him plead guilty and admitting under oath to what the facts are and agreeing to go to jail, and he's going to be in jail, he's going to be sentenced to his jail time during this trial, right? Right before this trial. So he's going to be neutralized so that if Donald Trump calls him as a witness, at least he has to admit what he just admitted under oath in his perjury conviction. So, and then they can always cross-examine him if Donald Trump calls him. So they neutralized him, so he can't now, because otherwise, had they decided, oh, well, he lied to Judge Engoron, so we're not going to call him as a witness, but then Trump could put him on the stand, right? Trump could put him on and say, no, it wasn't Trump. It wasn't the way they're saying it is. They had to get him to admit what the actual truth is so that he can't now be a witness for Trump. So I'm not sure they're going to call him or not, but they're keeping their options open. And as I said, they wanted to neutralize him as a potential defense witness. And I think that's what's going on there with this Weisselberg perjury plea, just given the timing, the charges, and that he's doing it. That's my opinion on that.
I think you're exactly right. I think they are inoculating him just in case. As you said, if he takes the stand for Donald Trump, you just pled guilty to lying under oath to a New York State judge related to Donald Trump and business record fraud, didn't you? And then so that is a inoculator in case Trump was considering calling him, because now flipping over to the trial side, the trial thought process for the Trump team is, how do we put Allen Weisselberg on now that he just pled guilty to perjury? Hasn't that removed him from the running of being a witness for us? And so, like you said, playing offensively and defensively at the same time, the Manhattan DA's office takes him out of the running, right? Just picks him off, because there's no lawyer in their right mind, and I know what I'm saying has a certain amount of irony baked into it with the Trump lawyers, but no lawyer worth his salt is going to, like Susan Necklace, is not going to call Allen Weisselberg. And then, as you said, if things go a little awry with Michael Cohen's testimony or somebody else's testimony, and they think that to bring it home or to fix something, they need Allen Weisselberg, well, then sort of like Silence of the Lambs, they wheel in Allen Weisselberg with a mask on a gurney in front of the jury, and they put him in the box, and the same prosecutors that are prosecuting him and he hasn't been sentenced yet in front of, don't you think the judge for the sentencing, even though it's the Manhattan DA's case against him related to the New York Attorney General, is going to be Merchan? Isn't it the same judge?
Yeah.
Right. So picture this, wheeled in on the gurney, the judge that's about to sentence you, who already has problems with you, if you're Allen Weisselberg, the last time you testified, because he thought that Weisselberg didn't properly cooperate, and that's why he sent him away for 100 days to Rikers Island. But now Allen Weisselberg fired his Trump-appointed lawyer, and hired a well-known white-collar lawyer here in town that I think, Karen, you probably know him too. And they're starting to make better decisions, including taking this plea deal. And so he steps in there, and they stick him in the booth, and he's staring down the prosecutor that's prosecuting him, the plea deal that they'll yank from the table if he doesn't properly testify, and the judge is going to sentence him, and he's being forced within an inch of his life to testify to the few facts that they may need, like you said, should they need him. So he is break the glass emergency witness, and they've completely conditioned his conduct by getting him there. It's not what's the word I'm looking for? The timing of the conviction, the plea deal, as you noted, Karen, is on purpose. Just to send the message to the other side. You thought you were going to use Weisselberg? You're not. If anybody's going to use him, it's going to be us. And we have him on such a short leash, he may hang himself in front of this jury and get convicted again if he doesn't play ball. So you have to do it if you've got the guy. And we've been hearing about, again, a shout out to Alvin Bragg, who took a lot of heat in the first year of his tenure as the Manhattan District Attorney's Office, including a little bit from this podcast, about how masterfully they are conducting themselves in advance of the getting ready for the seriousness, the gravitas of the only criminal trial that likely to happen against Donald Trump before the November election. And so we've been hearing about the perjury for over a year. And then it happened again. We knew they were squeezing Allen Weisselberg to get him to flip. And then we said, oh, well, it didn't really happen with the conviction, the tax evasion conviction. And then they got him again by the short hairs when he lied on the stand during the New York Attorney General case about the size of Donald Trump's penthouse to Forbes magazine, where Forbes reported in real time while he was testifying, Allen Weisselberg just perjured himself on the stand. I mean, talk about having, as a prosecutor, having the entire package with a ribbon tied around it delivered to your doorstep. The Forbes in real time said, we were told the exact opposite in emails. Here they are by what he's saying on the stand. He just perjured himself. And the Manhattan DA was like, let's get Allen back in here with his new lawyer and see what we can do.
Yeah, let's make a bet.
Yeah.
My bet, they don't call him. They don't call him. I wouldn't call him. He's willing to commit perjury for Donald Trump. Why would you risk that? I
agree with you. They only call him if, in an emergency, something bad has happened in the courtroom in front of that jury, and only Allen Weisselberg can fix it, which is a lot of stuff there. But they've totally, like you said, they've taken him off the witness list, apparently, obviously, for Donald Trump, which is a win. Which is a total win, because he's a puppet. All Donald Trump has to do is shove his hand up his backside. It's like watching the Muppet Show, and he's like the two old guys up in the in the opera house. Like he'll say whatever Donald Trump wants him to say. Not anymore. Not anymore. So let's move on. We'll follow it. There's lots of activity and action between now and the day of the jury. It starts to be picked on the 25th or 26th of March, and we'll cover it right here on the Midas Touch Network on Legal AF. But let's turn to Judgment Day. Judgment Day. We're going to talk about Judgment Day and Donald Trump having to scrape up $600 million or so. How is he going to do it? The bond process, the cash process. All of his efforts with judges have fallen on deaf ears to try to get the judges to let him out from under his obligations, including appellate court judges. So what does he do with tomorrow? Is he going to go find that $100 million that's lying around in his couch and post it, or is he going to do something else? We'll talk about that, and then we'll talk about Ken Chesebro, the fake elector scheme, and what it means for Donald Trump. But First, a word from our sponsors. Did you know that your temperature at night can have one of the greatest impacts on your sleep quality? If you wake up too hot or too cold, I highly recommend you check out Miracle Made's bed sheets. Inspired by NASA, Miracle Made uses silver-infused fabrics and makes temperature-regulating bedding so you can sleep at the perfect temperature all night long. Using silver-infused fabrics originally inspired by NASA, Miracle Made sheets are thermoregulating and designed to keep you at the perfect temperature all night long, so you get better sleep every night. These sheets are infused with silver that prevent up to 99.7% of bacterial growth, leaving them to stay cleaner and fresher 3 times longer than other sheets. No more gross odors. Miracle sheets are luxuriously comfortable without the high price tag of other luxury brands, and feel as nice, if not nicer, than bed sheets used by some 5-star hotels. Stop sleeping on bacteria. Bacteria can clog your pores, causing breakouts and acne. Sleep clean with Miracle. Go to trymiracle.com/legalaf to try Miracle Made sheets today. And whether you're buying them for yourself or as a gift for a loved one, if you order today, you can save over 40%. And if you use our promo LegalAF at checkout, you'll get 3 free towels and save an extra 20%. Miracle is so confident in their product, it's backed with a 30-day money-back guarantee. And if you're not 100% satisfied, you'll get a full refund. Upgrade your sleep with Miracle Made. Go to trymiracle.com/legalAF and use the code LegalAF to claim your free 3-piece towel set and save over 40%. Again, that's trymiracle.com/legalAF to treat yourself. Thank you, Miracle Made, for sponsoring this episode. Most clothes are uncomfortable, or too tight, or never actually the size you really are, not to mention the annoyance of trying to put a good outfit together. Everyone wants to dress their best and look good at all times because, frankly, it's a confidence booster. I regularly wear Rhone when I do the podcast or on Hot Takes. So here's the deal. Men's closets were due for a radical reinvention, and Rhone stepped up to the challenge. Rhone's commuter collection is the most comfortable, breathable, and flexible set of products known to man. And here's why. Rhone helps you get ready for any occasion with the commuter collection, which offers the world's most comfortable pants, dress shirts, 1/4 zips, and polos. Rhone's comfortable 4-way stretch fabric provides breathability and flexibility that leaves you free to enjoy what life throws your way. From your commute to work to your 18 holes of golf. It's time to feel confident without the hassle. With Rhone's wrinkle release technology, wrinkles disappear as you stretch and wear the products. It's that easy. With Gold Fusion anti-odor technology, you'll be smelling fresh and clean all day long. And on top of that, Rhone is 100% machine washable, so you can ditch the dry cleaner altogether. Rhone has truly become my favorite clothes. We're on the move a lot. Whether it's jumping from meeting to meeting or catching a flight or a dinner out, the Rhone commuter collection has never let me down. Even after I wear it all day, I still feel super fresh because of that Gold Fusion anti-odor technology. Head to Rhone.com/legalAF and use promo code LegalAF to save 20% off your entire order. That's 20% off your entire order when you head to RHONE.com/legalAF and use code LegalAF. It's time to find your corner office. All right, and we're back. And again, we thank the sponsors for being here, and we support them, and we hope you will too. Judgment Day. Karen, does Donald Trump, will he or won't he? Does Donald Trump come up with $100 million cash to stop the E. Jean Carroll judgment from being enforced against him? Or does he do an unforced error? He serves the ball into the net and allow Robbie Kaplan, representing E. Jean Carroll, to go start using the sheriff's office to execute the judgment against his assets. The judgment's against Donald Trump. How many Donald Trump assets are there, as opposed to being in the trust or in other limited liability companies? How hard is it going to be to collect that money? And then, even if he comes up with $100 million for that, he's down to a self-proclaimed $300 million. He's down to $300 million in his bank account, which is not enough to put up the cash bond for the other New York Attorney General judgment, which means he'd have to go to a bonding company or get a letter of credit. So let's talk about all that. What do you think happens next?
I have a question. I love asking you questions. So I read in the paper today that Donald Trump was meeting with Elon Musk. Do you think that was in an effort to get money to pay these judgments?
I did. until Elon Musk came out today and said I guess you have to interpret this.
Yes.
He said he's not going to contribute to either political campaigns.
Correct.
But is he going to be the funder and the financier for Donald Trump?
That's what I was. I read what you read, and I thought that's not why he's meeting with Elon Musk. He doesn't care about a campaign contribution. He's looking to have him fund his judgments and making some secret deal on the side of, pay this, let me get me to be, I'll get the money to become president, and who knows what the agreement is between them.
Yeah, and as our producer just put it so bluntly and correctly, Musk needs Trump. He's become very Trumpy. He's got a lot of issues that would be helped by the restoration of a Trump presidency. But Elon Musk has his own money problems. I mean, we didn't cover it here because it's not quite at the intersection of law and politics, although it's getting closer based on your observation. But a Delaware Chancery Court just shot down a $56 billion pay package for Elon Musk, saying that it was improperly approved and he's not allowed to get that money. He's lost hundreds and hundreds of millions of dollars in his failed experiment called X, as we know. And, he'd have to sell off more Tesla stock. And that's a lot. I mean, look, dollars between friends, 5, 6, 700, $1 billion between friends. I'm not sure they're that close of amount of friends, or an overnight visit at Mar-a-Lago is going to make them that. But we will see it. By the way, I don't know, just as an aside, did you see that the contingency fee lawyers in the against Elon Musk asked the judge for $6 billion in fees? They said they were entitled to a third of the $56 billion, but they'll just take $6 billion. I know that firm.
We're representing the wrong plaintiffs.
I know. I'm in the wrong kind of cases.
we're the wrong kind of lawyers.
We're for politics and justice. That doesn't make us as much money. Anyway, I like the Elon Musk. We'll have to keep, one eye open about all of that. But tell me what you think about, what is Donald Trump doing? Where's he going to get the money from? Is he going to get the money? If he doesn't, what happens on Thursday and 2 weeks from now?
I mean, he's either going to come up with the money somehow, or he somehow likes the political theater of being the victim. And so he would like to force the hand of Letitia James to have to put a padlock on his airplane. Oh, look, the Democrats trying to steal my airplane or steal my building or whatever. I mean, I'm sure he's making that calculation, because he could come up with this money, not because he has it, but he has access to at least $100 million, right? Because we know that, because that's what he told Judge in the Judge Engoron case. He said, "Is it okay if I put up only $100 million, not the $500 million that would have to put up if you do the judgment plus interest, which is what you normally have to do. I have access to $100 million. So I think it's probably likely that he has that. And of course, Judge Lewis Kaplan in the E. Jean Carroll case probably reads the paper and reads court decisions, et cetera. So he knows that he has access to that $100 million. So when Donald Trump came, when his lawyers came to Lewis Kaplan and said, Can I have a stay on whether or not I have to whether the judgment gets enforced in the $83 million in the next couple of days, and I need a decision by today. And of course, Judge Lewis Kaplan, instead of just not ruling that day, it was like he was trolling him, because he then issues a decision that says basically, don't call us, we'll call you. I'm aware of your deadline, and I will rule when I rule. And so I think he'll have to come. I don't think he's going to want that enforced. I think he's probably going to put that up, and then we'll see if he comes up with the money for the larger judgment. What do you think? Do you think he's going to come up with the money, or do you think he's going to go for the political theater part?
No, I did a hot take on it. I think he has to come up with $100 million. I think it'll probably be cash in E. Jean Carroll. And then he's going to try to continue over the next 20 days to scrape together the $600 million that he's going to need with interest and 120%, which is required with interest running for the people's judge. I call it the people's judgment. The people of the state of New York's judgment in the New York civil fraud, the Attorney General civil fraud case. Problem there is he doesn't have the cash for that. And they're not going to take an IOU. Or, like I know I did a hot take about him being the king of debt, and he loved bragging in 2016 about, I love debt. I love negotiating with my creditors about how much I owe them. Well, you can't do that with the little thing we call the justice system and judges. They are not business people. And in this case, that's a good thing. And it's either every dollar on the barrelhead or the judgment is enforced. And so he's scrambling right now. There's no
what's
doubt.
An interesting legal question about that?
Mm-hmm.
So let me tell you what you think about. Let me ask you what you think about this. And maybe people have already discussed this, and I just haven't seen it. But there's campaign contribution limits, right? There's people one of his friends can't just give as much money as they want to his campaign. Do you think it would count as a donation to his campaign if somebody put up that money for him for this judgment?
I think there'd be an argument that it's an election law violation.
Yeah, that it's a contribution. He'll say, no, it's a loan.
Well, but everything's a loan.
I know, but I'm just throwing this out because I wouldn't be surprised if that's why he was meeting with Elon Musk. He's going to try to drum up the money somehow, and just let's put that out there. Let's start to do some research on whether or not that would be considered a campaign contribution, because if so, there are limits on what he can accept. And I think calling it a loan is going to be, I don't know that will immunize the legal issue.
Yeah, but the penalty, he'll be willing to pay the penalty as a cost of doing business, because the FEC, the Federal Election Commission, is pretty feckless, no pun intended, in how they go after people and the fines that they have for that. And so even if it's proven that, I just don't think I agree with you that it would probably be that. The more likely candidate to make that kind of contribution to him or loan to him is the Adelson family out of Nevada. The father died, but left it all to the wife. They're huge MAGA right wing, and they've got money that rivals Elon Musk's. And I could, but that's still, as I said before, it's not like 50 million among friends. 600 million, 700 million. That's a huge sum of money. Now, the issue is he's got it. He just has to liquidate assets in order to acquire it. And he doesn't want to do that. Look, he's got real estate. He owns buildings. Some of them have his name on it. Some of them are license agreements, but some of them he has fee simple title to them. He owns them. He owns Mar-a-Lago. Whether you call it, $100 million, which is more likely the value of it, maybe 150 million. He's got some money. What he's got to do is what I'm sure he is doing, which is he's going to private equity or hedge funds who are not New York registered or chartered banks. And we can name a bunch of them. They're all out there. Ladder Capital. There's a whole bunch of them that he's used in the past. Or smaller banks. So this number is so big, I doubt a smaller bank is going to touch it. And he has to get what's called an irrevocable letter of credit. In order to get an irrevocable letter of credit as an asset, saying that the person's going to make good on it, the bank or the hedge fund or the private equity fund will take this as an investment, and they'll take a pledge of assets. And if he doesn't and they'll charge him 12 or 15% interest on the amount that he's borrowing as a return on the investment for their investors. So they just see it as a dollars and cents thing. So there are hedge funds and private equity that would be willing to lend him money in return and to give him that irrevocable letter of credit. He then takes the letter of credit to a bonding company, and the bonding company charges them another 4 or 5% on the amount as well. Everybody gets their piece, and they put up the bond. And if he violates the bond, in other words, he doesn't pay the judgment, if after appeal, what we're talking about is if after appeals are exhausted, he has lost, and the judgments are undisturbed in whatever dollar amount that they are, he has to pay them. And if he doesn't pay them, they go against the bond, and the bond has to pay it. The bond goes against the letter of credit. The letter of credit has title to the properties, and that's how everybody gets paid. He's got to be doing that. He's played with fire and played chicken with federal and state judges and appellate courts long enough. He's got to do that. But so back to your original point, no, I don't think he's going to allow Trump 1, Air Force, whatever, to be padlocked or his, the look of a sheriff's office. Think about the media, not just Midas Touch, of a padlock on one of his properties with a sheriff's sale. I mean, I was outside the country for a vacation. Some people know about who follow me on social media. And there in this country was a giant sign that said that the mega yacht owned by the Russian oligarch was now the property of that country and was being sold at auction that Monday for $63 million. Donald Trump does not want that look right now. And so what I think the silence that we're watching is, while the lawyers are out in front trying to act like we need more time, people in the back are I don't know if it's Eric Trump, Don. I haven't heard from Eric Trump or Don Jr. lately, or maybe Jared, are working their relationships. I mean, look, the Saudi government, the private investment fund, the PIF, that was going to put all of its money into the PGA, could put their money into Donald Trump. There we go. Now we've got a presidential candidate bought and paid for by the Saudi government. There's no limits on where the money can come from. It's just up to the American people, if it's going to be the Saudis, to say, you know what, I'm not okay with our president being bought and paid for by the Saudis. But that's, look who's got money. When anybody, I'll just give you my Wall Street experience, having worked at a giant Wall Street company for a period of time as their global head of litigation. When you need money, you go hat in hand to the Middle East. You go to Dubai, right? You go to countries there. You go to the Saudis, hat in hand, and you get money. And there's a lot of free-flowing money there. It used to be the Chinese. It's more the Saudis now. So could be Elon Musk. It's going to be somebody. And the other issue is, I'm not sure it's going to be revealed, because he doesn't have to reveal it. All he's got to do is come up with a piece of paper that says the bond. And how he got that bond? Now, the Monitor, just to leave it on this, the Monitor, Barbara Jones, to the extent that assets under her monitorship, established by the New York Attorney General through or Judge Engoron through the New York Attorney General case, she'll have to know. And if he has assets outside of all the things she has, he's got a problem. So if he takes out a personal loan and there's a promissory note with a commitment, she's going to have to see it. So I guess I'll have to retract. I'm going to retrade what I just said. We will know, because she'll know. And therefore, she'll have to make a report to Judge Engoron about where the source of the cash is.
Interestingly, if one of Trump's billionaire friends like Elon Musk or, MBS or anyone else, right, who wants to pay Trump's judgment, if they say this is a personal gift, has nothing to do with the campaign, I think that the campaign finance laws don't get implicated, which is just shocking to me as a workaround, because to me, it's an illegal campaign donation. I can tell you right now, there is no way any of these people would be contributing this money, but for the fact that he is running for president and they want to install him in office. So,
how about if it's the Saudis? Foreign money, which is illegal as a contribution.
Yep.
So,
but all they have to do is call it a personal gift, and the election laws don't get implicated. So
all right, we'll follow.
Let's not only follow, let's call it out, because like I said, there's this but-for test, right? If he was just, there's no way they're doing it just so they hope to get invited to Mar-a-Lago. They're doing it because they want to make him president.
Right. Speaking of wanting to make him president, Ken Chesebro, Jim Trupis, two lawyers wanted to make Donald Trump president, and they helped develop, along with Peter Navarro, the fake elector scheme at the behest of Donald Trump and the campaign, as alleged in the indictment and Jack Smith's indictment. And now Ken Chesebro has a new problem of his own making. He lied, apparently, to the Michigan Attorney General, the Arizona Attorney General, and Jack Smith, I would think, about his advice and role in the fake elector scheme. Let me frame it. Karen, comment on it. And then you'll know more than you did before you joined this podcast about poor Ken Chesebro. Ken Chesebro is a self-proclaimed election law expert, and half-baked constitutional scholar. He and John Eastman, who was a constitutional law professor, cooked up a scheme to create an alternate slate of electors in 7 battleground states, use that certificate, have them meet surreptitiously in the middle of the night somewhere on the Capitol grounds of each state, in the basement or somewhere else, sign a certificate, get fake electors to join in on it, send it through a circuitous route using a mule in Mike Roman, who's been indicted in Georgia, also at the heart of the attack on Fani Willis and Nathan Wade, by the way, and use Mike Roman, the election day coordinator for Donald Trump, bring those fake elector certificates through the halls of Congress, not making this up, through congressional aides that worked for a member of Congress out of Pennsylvania to deliver them at the feet of Mike Pence to try to pressure him to recognize one or all of those certificates instead of the real slate of electors for each state to make Joe Biden the president, and throw the entire thing into some sort of chaos so that it would be the election would not be decided by the electoral vote based on the popular vote in each state, but by the House, which is, if you just count congressional delegations, not by size, but by number, there's more Republican delegations than there are Democrat. And so Trump would win the presidency despite our vote. That's all Ken Chesebro did. But when he gave his testimony to Fani Willis and to Arizona and Michigan, he just said, no. My advice, I'm just a lawyer. I'm just a poor country lawyer wearing a MAGA red hat, walking around on Jan 6th with Alex Jones. All I said was create the fake the alternate electors, but only use them if one of the lawsuits is successful in any of these battleground states and there's a decision by a judge based on evidence that there's been fraud. That's all I said. That's not all he said, because there's 1,400 emails that have come out of a case that we followed in Wisconsin, brought by different fair government, fair election groups against the fake electors there, and Jim Trupus, a lawyer from Wisconsin, who worked with Ken Chesebro, and they sued them directly, and they had to admit that they participated in election fraud, and they committed to never doing it again. Yay! But there was also 1,600 documents, emails and text messages, mainly between Trupus and Chesebro, which is completely different than the testimony that he gave to under oath to all of these people, and the basis for his immunity or proffer deal, meaning they could now prosecute him for perjury, because in those texts, he said, yeah, we just need the fake electors for political cover. Just get us into the halls of Congress, and then Mike Pence can sort of recognize them. No mention of the lawsuits. We don't need the lawsuits. We don't need no stinking lawsuits. All we need is fake elector certificates, which is exactly the opposite of what he told to all the investigators who were just trying to do their job and investigate what really happened here. And then, he has there's a new version of what went down when Trupus and Chesebro met with Donald Trump for a photo op in December, right after the election, before Jan 6th, that was arranged by Rance Priebus, what a name, who used to be the Republican national chairman. Then he became a short-time chief of staff, one of the many chiefs of staffs for Donald Trump. And he arranged this photo op, and instead it became Ken Chesebro whispering in, like the horse whisperer, the Trump whisperer, into Donald Trump's ear, telling him, really, the last day is Jan 6th. It's all about Jan 6th. And then when Trump tweeted, come Jan 6th, it's going to be wild, we have a text message between Trupus and Chesebro where he said, see, you did this. We have a newfound context for what, we know what this means. And then when Trupus saw, what's his name? Chesebro wearing a red hat, walking around as an insurrectionist, he said, yo, you made this happen. Clap, 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 clap emoji. Oh my God. Prosecutor, Madam Prosecutor, what do you do with a problem called Ken Chesebro now that you know what that he lied to the prosecutors? What happens next?
I mean, liar, liar, pants on fire, right? I mean, this guy, he just can't stop lying. This is another one where he's clearly going to get in trouble in Nevada, right? He's going to get in trouble back in Georgia. And I really just think Ken Chesebro is proving himself to be somebody who can't really be a witness for Fani Willis because he's such a liar. I never really was 100% sure he was going to be a witness for Fani Willis, because his plea allocution, if you recall, was so weird. He didn't really admit to anything. It was one of those plea allocutions that was a non-allocution. They basically said, if I remember correctly, something like, I admit to whatever, count 17. Like he said nothing. And same thing with his apology. His apology was, I'm sorry for hurting people, for the things I did in count 17. Like he never admitted to any facts. And I remembered that there was a detailed factual allocution, but when I went back and re-listened to it, it was the prosecutor who said, these are all the facts they would have proved. He never said that he was going to do that. And they didn't make him do that. And so the reason I say that made me wonder whether he's going to actually testify and cooperate for Fani Willis was because if he was, they would have wanted him to under oath admit to the facts so that, again, that he said it, that he's going to say it under oath. And if he doesn't, he can't go turn around and say, oh no, I didn't mean it later, or change his mind later, because they lock him in. So I always thought, just based on that flimsy allocution, that he was in some weird, purgatory state. He wasn't really a cooperator. He wasn't really a cooperator. He was he was neutralized or inoculated, to use your word, Popok. But then when you see then if you remember, he was under house arrest. He couldn't leave the state of Georgia. And he asked for permission, right, to the court, to Judge McAfee, to say, I want to go cooperate and in the other states. And now it's coming out, what you just described, it's all coming out that he's still lying. He is still lying on behalf of Donald Trump. He will not give all this up. He will not let it go. That that he really, I think, is digging in and digging his heels in on the fact that this fake elector, that this whole thing, that he could still go along with this fake elector scheme. I think he's maybe got a new spring in his step. He thinks that Donald Trump is now, he unfortunately is leading in the polls. He's going to be the Republican nominee after Nikki Haley just pulled out. And so maybe he's making a different calculation here, that now he can kind of go back to his other, it's like he keeps switching, betting on different horses, right? First he bet on Donald Trump in just the whole fake elector scheme. And then when his ship started sinking, he then flipped to the other team. And then now he's, I guess, sees the winds blowing a different direction, and he seems to be flipping back to the Trump team. And, people are calling him on it, right? People are calling him out on his lies. So it'll be interesting, right? It'll be interesting to see what happens. But he's made himself out, I think, to just be somebody who's just not credible and really can't be of value to anybody. So I think he's going to get slammed pretty hard.
Yeah, these lawyers, I don't know, they're like in some sort of voodoo trance of Donald Trump.
They really are.
And I've never seen anything quite like it. They just are willing to follow him over the precipice and sacrifice on the altar of his megalomaniacal power grab their ethics, their law licenses, their profession. We see it sort of time and time again. But we're going to follow all this. We're going to follow by next week at this time. We may have the decision by Judge McAfee and the Fani Willis, Nathan Wade. Will they or won't they be replaced as prosecutors in the Georgia election interference case? Will Judge McAfee ever get around to setting the trial of in the election interference case arising out of Georgia law there at all? Speaking of will he or won't he, we'll also be that much closer, probably start seeing a further briefing in the Mar-a-Lago matters related to whether she's going to make a false step. We think she has already, but in a way that Jack Smith, with his new bench, his new lawyers, can take advantage of it and take that appeal that we've been waiting for to the 11th Circuit to get them to weigh in. 11th Circuit can't weigh in unless there's an appeal. I think they're just waiting for that opportunity on both sides. And we'll know more about that next week. Ben and I will have an opportunity to read through the new briefing that's now been invited by and accepted by Judge Cannon in Mar-a-Lago. So we'll probably spend on Saturday a lot of time talking about Mar-a-Lago. I'll have the interview with Judge Ludig, who, was busy running around to mainstream media, but literally wants to be, told me personally how much he wants to talk to our audience and made time on his schedule to do that. And I can't think of anybody finer to talk about the constitutional issues than somebody who was this close to being on the United States Supreme Court and is, by all accounts, a federalist and a conservative, but at bottom is a patriot. We'll have that interview as well. If you want to support what we do here in the Midas Touch Network, it is about as simple as it can be. You're already here on the Midas Touch Network. And if you haven't already decided to subscribe, it's free. All you got to do is use your fingers and thumbs, go back out and free subscribe. Just hit the subscription button and help the network get to 3 million before Election Day. We are literally building the network with your help. We're independent. We're grassroots, no outside investors. And so we are the network that you were looking for and that you're helping to build. And we appreciate you being here, part of our audience. You're watching already, so that's already part of the algorithm, but the comments, not just the chat. We love the chat. I love the live chat and we participate in the live chat, but the comment section and the thumbs up section, you go back out to the front of the podcast, thumbnail, so to speak. That helps. As I joke on my hot takes now, it's not like cable news. Eyeballs are not enough to register as ratings. The way things register on YouTube and tell the world, including the YouTube gods, that we are at the top of our game is if you kind of participate and interact with the content by way of these comments and thumbs. So we ask you to do that as well. Then we've got a whole nother set of algorithmic gods over on the podcast world, the audio podcast world, and go over and listen. We'll drop this audio in a few more hours after we're all done here, and it'll be up on Apple, Spotify, Google, wherever you get your podcast from, and you can rank and rate us there as well. That really helps us in kind of going back and forth. We've got these, what we call Legal AF After Dark. We take the 4 segments or so that we do tonight and on Saturday, and we release them as individual, I like to call them podlets, and that's really for people that didn't have time to watch the entire show. It's an investment. We're an hour and 20 minutes in. It's an investment, but we break it down for you in bite-sized pieces. But it's also a way to promote the show. You can take that clip when you see it, you'll know it because I introduce it as Legal AF After Dark. Take it and send it to people in your life. Like, hey, you know that podcast I like, Legal AF? Here's an opportunity to listen to it and see why I like it. And maybe they'll join our audience. And then we also post it for people who, frankly, are on the Midas Touch Network and they follow other content providers, but they don't know anything about Legal AF. I know that's hard for people to believe, but there are people who don't know about us. So that's a way to do it. And then finally, besides all of that, there are in our interviews that are sort of related to this, and we do guest appearances on other shows on the Midas Touch Network. Like we've been on Lights On, and I've been on Michael Cohen, and Karen will be too, maybe one day. We will. You can fly the flag of Legal AF, and you can do that by buying merchandise that we redesigned recently, including T-shirts that are properly sized and shaped and colored and logoed. And you can get it there at store.midastouch.com. And the other way is, I'm just going to be crass for a minute, supporting our sponsors. It really does matter to them. And they like to sponsor because they're getting, let's be frank, sales from people that watch our show. And we like to be able to tell them that our show is a good place for them to advertise and don't take their advertising dollars and put it somewhere else. So now that we've reached the end, Karen, I'm glad you're feeling better.
Much better.
And I know that while you don't have sort of, insider knowledge to the Manhattan DA's office, I can't think of anybody who's better to talk about things, especially in the world of prosecutorial landscape, than you. And it's always my honor and my pleasure to do this show with you.
You too, Popok.
Thank you. So until our next Legal AF, till our next series of hot takes by Ben, Karen, and me, shout out to the Midas Mighty and the Legal AFers.